Good afternoon, ABA Division for Public Education friends. As always, I am thrilled to be joined here on our YouTube channel with Professor Steven D. Schwinn of the University of Illinois Chicago School of Law. We are going to dig into some of the fast-breaking cases coming out of the U.S. Supreme Court at the end of June. Professor Schwinn, thank you for being here and for digesting these cases so quickly to help us learn from them and to learn from you. I'm thrilled to have you here and to dig into some of the cases that have dealt in some ways with property ownership and the right of property owners. Can
Yes,
you
indeed.
start us off? There was a case coming out of California dealing with labor organizers and their ability to access the fields of growers. So can you talk to us a little bit about Cedar Point Nursery versus Hassid and what happened and what the court had to say about the rights of property owners here?
Yeah, absolutely. Really, really interesting case, Kathy, and really important for takings purposes, property purposes, and labor organizing purposes. So California has a law that requires agricultural property owners, agricultural businesses, to open their workplaces for 3 hours a day for 120 days of the year for labor organizers to communicate with the workers in order to organize them. Now, this is a really important thing for labor organizers because it turns out in the agricultural industry in California, it's really hard to locate workers in a collective place outside of their workplace. So if unions want to organize the workers, they really have to get in touch with them at the workplace. The California legislature recognized that and said, okay, so we're actually going to require businesses that run agricultural businesses, we're going to require them to open their workplaces for an hour before business, an hour over lunchtime, and an hour after business hours for 120 days of the year for union organizers to communicate with workers on the work site. Now, the businesses didn't like this one bit. What they said was that that amounts to a taking of their property. Now, this may sound like a really unusual kind of claim.
Yeah.
A taking would usually be where the government, for example, takes your house or my house in order to build, say, a road through where our house used to be, right? And when the government does that, it's exercising its power of eminent domain. It takes our house, it provides fair compensation for our house based on the market value of our house, and then it goes ahead and demolishes the house and builds its road. It's not at all what's happening here. What's happening here is very different. The state is regulating the property to a degree that the owners have to provide access. So this was key to the court's ruling in the case. Is this the kind of claim where the government is physically taking property, which is a per se taking, and automatically triggers the just compensation requirement? Or is it a kind of taking that's what we call a regulatory taking? A regulatory taking is where the government regulates one's property to such a degree that it amounts to a taking. So the dispute here was in part, or at least initially, whether this was a per se physical taking or a regulatory taking that might give the government a little bit more leeway to regulate the property. And what the majority said in the case, this was a 6-3 case. It divided along conventional ideological lines. The Chief Justice wrote the majority opinion for the 6 conservatives on the court. And what he said is that this is a per se physical taking of the property. That what the rule does is actually require the property owners to give up a portion of their property rights so that labor organizers can come onto their property, even for this limited period, in order to organize. And that if the state's going to do that, it's going to have to provide just compensation. Now, what the dissent said, and the dissent was the 3 progressives on the court, what the dissent said is, no, that's not right. This is a regulatory taking. The government is regulating the property, and the government can do that so long as it doesn't regulate to such a degree that it amounts to a taking under the takings clause. And so, you had a conventional split on the court. You had two very different views of what the government is doing here and two very different views of what the property rights and property interests of the business owners are, as against the labor organizing interests of the unions that wanted to come onto the sites.
Steve, there is a ton to unpack in this case. I have starred and noted as you were talking about all the points I want to make sure we hit upon. Can you start just by talking about this notion of sort of the remedy here? So it isn't that the court, or clarify or sort of hammer a bit more, the court's not knocking down this law, right? You said per se takings equate to just compensation. So they're expected to pay the landowners here? Is that sort of what will happen?
It depends a little bit on what the plaintiffs are asking and how the state reacts. And Justice Breyer talks about this a little bit in dissent, but the way the case came to the court in the first instance is that the property owners, the business owners, were actually asking for an injunction. They wanted the courts to enjoin the enforcement of this state law so that the state could not allow or would not require business owners to admit union organizers onto their property. And that's one way to go about a takings claim. But the takings clause is one of these unusual clauses in the Constitution that actually contains its own remedy. So if the government takes property for public purpose, it can pay just compensation and satisfy the Constitution. That's the government's exercise of eminent domain. So if California, in this case, comes back and offers just compensation for the access that its law is demanding, and how do you calculate that? That's right. A different question entirely. But if indeed it provides that just compensation, then it really has remedied its own constitutional violation, and there's no constitutional problem at that point. So, what's going to happen next? We don't really know. California could decline to enforce its law consistent with an injunction against it, or it could seek to provide just compensation to the property owners and remedy its own violation in that way.
So, Steve, without knowing what the state of California will do in this particular case, how do you see this case sitting within the broader rulings that this court has been issuing when it comes to labor organizations and labor rights over the last 10 or so years? And I'm thinking, if we have teachers watching this, most specifically of Janice, but this is a set of justices that have had some things to say about labor. And does this track with that? And where do we see this potentially leading?
Yes, absolutely. It tracks with a jurisprudence on the court that is, I'll say, anti-union, perhaps even hostilely anti-union. And so it's consistent with that trend. It's consistent with a trend of protecting property rights. And we'll talk about this a little bit with Lange in a very, very different context. And so, yeah, it is, I was going to say broadly consistent with the court's trends in these areas. It's perfectly consistent with the court's trends in these areas.
Yeah. So continuing on sort of the questioning of where does this take us, I thought Justice Breyer in his dissent sort of sounded a bit of an alarm or at least a red flag, if you will, about what this could mean for government regulations and sort of the regulatory exercise of local government. And he gives the examples of sort of how food's prepared or daycare regulations and ensuring daycare safety. Is he accurate? Is he sort of doing a slippery slope argument here? And what does this actually mean for the ability of government agencies or third parties that the government may give permission to ensure safety in a variety of contexts?
I think that's a really hard problem. And so the issue here is, a number of different government laws allow or require periodic visits by inspectors, for example, and you had mentioned a couple of examples of this, and whether this ruling would mean that those laws similarly effect a taking that would trigger just compensation or just striking the requirement entirely. The chief in the majority opinion tries to work around this and says, there have been long-standing practices of granting, for example, business permits on the condition that the business comply with certain government requirements, which would also include inspection, for example. And so the chief's opinion attempts to work around that and say, no, that's not really going to be a problem. But I actually think probably the next round of litigation here is going to be on exactly those kinds of requirements. Now, you do have a 6-justice majority and really a unanimous court here saying that those kinds of requirements are not struck by this ruling. And so I want to be clear about that. But what does it mean for the future? Well, I think we probably will see some litigation taking on at least some of these kinds of inspection requirements.
And before we turn our attention to the other case we're going to be discussing today, I know you're not a property professor, and your expertise and interest is really constitutional law, but since it's tied up in a constitutional law case, what's the difference between a trespass and a taking here? That was kind of my shorthand was, well, why isn't this a trespass? And how is this different than sort of our common expectations of saying, I'm not going to allow you to come onto my property and it's a trespass for you to come onto my property?
Yeah, so this idea of trespass is well rooted in our property law. What it means is that the government can prohibit and regulate a person coming onto your property, and in fact, you can prohibit a person coming onto your property if you don't want them to. The way we think about property, we talk about this in our first year property class in law school, is as a kind of bundle of rights, right? And so one of that bundle is the right to exclude when we want to exclude. The difference here is that while we can exclude a trespasser, for example, somebody that we don't want on the property, the government can require that some people come on our property from time to time in order to do things like inspections, for example. And if the inspection is reasonably related to the purpose of a government permit or a government license, then the courts are what the chief says in the majority opinion is that the courts ought to uphold that as a reasonable sort of quid pro quo for the government license of a business, for example. So even if the business could exclude a trespasser, the business could not exclude somebody who's lawfully come onto the property to inspect the business for whatever purpose under the law. But again, that's the linchpin here is whether the inspection has a reasonable relationship to the business license in the first place. And so again, I suspect we'll probably see some litigation around that issue in the wake of this opinion.
Great. Thank you for that very helpful explanation and flashbacks to first year property law.
For better or worse, right?
For better or for worse, indeed. So sticking on sort of the topic of property rights generally and who can and cannot come into someone's home or onto someone's property, I would love to turn our attention to Lange versus California. So this is a case coming out of a California criminal case. And I think we talked about it back in March when there was argument. It's a really interesting set of facts. The police had assumed that Mr. Lange, or had reasonable suspicion that Mr. Lange was potentially driving under the influence. He was flashing lights and playing some music. And he, in the pursuit of Mr. Lange, the police came onto his property. And the important distinction here is that in California, driving under the influence is a misdemeanor. So Steve, what did the court have to say here about misdemeanor pursuits of misdemeanors in the Fourth Amendment and entering into somebody's home?
Yeah, so this was a really factually interesting case. We did talk about it back in March, but what happened here is the officer saw this driver and thought, that driver's behaving in a way that suggests that he might be impaired. So police officer follows the driver, at one point turns on his lights. The driver does not obey the police officer And at that point, the driver has committed a misdemeanor, the misdemeanor of not obeying the police officer. And so when the driver then pulls into the driver's garage within the what we call the curtilage of the house, within the house for Fourth Amendment purposes, the police officer pulls up behind him, sticks his foot under the garage, triggering the monitor to put the garage back up, and then walks into the garage and tests the driver for alcohol and tests positive, and then arrests the driver for driving while intoxicated. The question is whether the officer can enter the house without a warrant in pursuit of a person who has committed a misdemeanor. Now, this is an important question because an officer can pursue somebody into their house without a warrant. This is an exception to the warrant requirement under certain circumstances. So in hot pursuit of a fleeing felon, for example, is an exception to the warrant requirement to enter a home for Fourth Amendment purposes, or exigent circumstances, for example, where a suspect may destroy evidence or pose a threat to the suspect's self or to other people. An officer doesn't need to wait around to get a warrant. But in a case like this, you think, well, the officer pretty easily could have gotten a warrant. They can get warrants really quickly these days, and gotten into the house and gotten the evidence that the officer was suspecting, the evidence of driving while intoxicated. That the officer didn't need to rely on a kind of categorical exception to the warrant requirement in order to do that. The California court said that there was this categorical exception that allowed an officer to pursue a fleeing person who had committed a misdemeanor. That question then went up to the Supreme Court, and the Supreme Court said, no, there's not a categorical exception to the warrant requirement. We're going to deal with this on a case-by-case basis, which is what the court really has always done in situations like this. And that means we're going to look carefully at the facts to determine whether the officer needed to get a permit, or I'm sorry, a warrant to get into the home under the particular facts of the case. And that's the way the court ruled. It was a unanimous ruling, but highly fractured. We had a lot of different opinions here. But, you know, at the end of the day, what it says is that there's not a categorical exception to the warrant requirement when an officer is pursuing a person who committed a misdemeanor.
And so, Steve, does this mean that in different localities, based on how a crime is categorized by the criminal statute, that the Fourth Amendment application or the Fourth Amendment protections are different for different fleeing suspects?
Kathy, that's exactly what the court was concerned about in oral argument.
Yeah.
And because misdemeanors are defined so differently in different jurisdictions, if there were a categorical misdemeanor exception, that might mean one thing in Illinois, where you and I are, and a very different thing in Maryland or Texas or California or wherever. And the way the court ruled in the case is, no, we don't have that problem, because it'll be a case-by-case under the facts situation. So whether the person committed a misdemeanor or not, I suppose could be a factor, but other factors are going to be much more important. Like, does the person pose a threat to public safety? Or is there a threat that the person's going to destroy evidence? Or are they actually in hot pursuit? Or in a case like this, where the officer just seemed to kind of, you know, casually wander up and trigger the garage door to go back up and casually wander in. I mean, there was nothing urgent about this. And so those things, I think, will probably be more important when courts analyze these cases in the future.
Yeah, it really felt like in Justice Kagan's majority opinion, it was a little bit of sort of resetting the table and taking a step back and saying, no, these are how we've always done this. These are the factors courts have long applied in these sorts of cases. And I know at oral argument and in some of the concurring opinions that maybe don't always read totally concurring in this case, There is some concerns about, we're putting a lot of expectations on officers to make split-second decisions. But I think Justice Kagan really clearly says we've long expected this. And if a situation is truly exigent, and we've had an exigent circumstance exception for quite some time, then yes, that exception applies. But if it's not exigent, as you said, he's strolling into the home, then there's no categorical exception here, and the officer has time to go and get a warrant. So for me, this felt to sort of a reset on some of this Fourth Amendment discussion, and a little bit of a treatise, if you will, on how Fourth Amendment case by case determinations have been made, and seemingly coming out of this case will be made.
Yeah, I like that idea of reset. It did. I mean, everything about it felt very familiar. The case-by-case approach, notwithstanding, the fact that officers do need to make split-second decisions. But, the court's jurisprudence in the Fourth Amendment area and in civil rights 1983 type cases, they understand that. They know that officers are making split-second decisions, and they take that into account when they're considering things like exigent circumstances as an exception to the warrant requirement.
Yeah, absolutely. Steve, I would love us to chat a little bit about the Fourth Amendment cases and some of the police interaction cases generally from this term, if you don't mind, because I think that these are cases that whenever I work with teachers and students are always just really interesting cases. And there's always a lot of classroom use that you can get out of some of these cases. So this case is the third of sort of a set of cases that the court dealt with this term, looking at the Fourth Amendment or how police interact with individuals. And as you know, I was closely watching the first case, Torres versus Madrid, which had originally, we were expecting last term. It got postponed due to the pandemic. And then I think there was some discussion about that case coming out of some of the Black Lives Matters protests over the summer and discussions of use of police force. It involved the police shooting at and injuring a fleeing suspect who then got away. And the question was whether the physical restraint of shooting her counted as a Fourth Amendment seizure. And I would note, it's not a traditional Fourth Amendment case. This was not like Mr. Lange, where we're dealing with his criminal conviction. We were not dealing with Ms. Torres's criminal conviction. Instead, we were dealing with whether or not she could bring a civil rights case against the police officers. But pretty clearly, the court this term said that this physical force was enough to qualify as a seizure. And I think that has some potential down the road for Fourth Amendment applications. And we could see some application and some challenges coming out of use of police force here. So it is certainly to some degree a restriction on what the police are able to do. Some would say a common sense restriction. Certainly the court was saying, there was discussions about bazookas and snowballs at oral argument, but really sort of applying a common sense use of the word force and the application of the force. And if the police intend to restrain you, then that's enough, regardless of whether or not they're successful. But I really think Lange is really interesting when looked at Caniglia versus Strom, which was another case in the latter half of this term. And it involved a domestic dispute. A wife called the police on her husband. She was worried that he was going to commit suicide. He had fled the premise. The police came into the home and searched and collected a number of firearms in the home. And the question was whether or not the police coming into the home at that point violated the Fourth Amendment. And the precedent that the court sort of struggled with was a case called Katie, dealing with a Chicago police officer and an off-duty Chicago police officer, and the search of his car and finding a gun in his car that was then subsequently tied to a murder investigation. And in Katie, the court created yet another exception, this community caretaking exception, and said in these instances, the Fourth Amendment, we're going to make an exception and allow the police to search when there's a worry about these firearms being out there. And what the court here said, which I think ties into Lange and even to some degree into Cedar Point, was saying no, the community caretaking exception does not apply to the home. And you hear the language in Caniglia, you hear the language in Lange about the home being the sanctuary, and we are going to protect your individual rights in the home above all else. And I just think, we said with Lange, it was a bit of a reset or a bit of a reaffirmation of some of these Fourth Amendment principles. And you see that in Caniglia, certainly. And I wonder going forward what we see from the court with some of these Fourth Amendment cases, and if there are any more threads coming out of some of these recent societal discussions we've had about police force.
Yeah, I think that's spot on. And, this is a court that's been protective of Fourth Amendment rights. We're seeing that now, as you said, for the third time this term, but we've seen it in other cases in recent terms as well. And in my mind, Kathy, that's often because you've got an alignment of ideas around, that sort of bring together both the conservative wing and the progressive wing of the court around sort of libertarian ideas that relate to the Fourth Amendment and require officers, for example, to get a warrant before they conduct a search, and a kind of suspicion of government and officer behavior, especially when it applies to the home. And so, you get a case like Lange that, while there are a number of different opinions, the court's able to come together in a result. And I do think we're going to see more and more of these kinds of alignments between the conservative wing and the progressive wing on Fourth Amendment questions.
There's one more case I would be remiss if we didn't mention when we're talking about the police interactions, and that's US v. Cooley, which was a case, it didn't get much media attention, and it's sort of a nuanced, strange little case involving tribal police officers and the authority of a tribal police officer to detain a non-tribe member on tribal property. And what I think is interesting in that case, when you compare that to particularly what we said about Lange, is that the court said, we don't want to make the tribal police officer have to make a split-second decision as to whether or not the person they want to pull over is a member of the tribe or not. And so that they have the authority to pull over anyone who's perceived to be committing a crime on tribal property. And so there is, I haven't fully processed it for myself yet, but I do think there is a comparison and some contrasting between how the court is dealing with these two seemingly similar fact patterns or issues, questions, but in very different settings. And I think US v. Cooley tracks more closely with what the court has done with tribal authority. And there's some interesting discussion that could be had there for teachers that deal with those issues in their classroom and in their school districts.
Yeah, for sure. And, Lange, I think, as you had suggested at the outset of this conversation, just really opens the door for a lot of really interesting classroom discussions and debates about the extent of police authority under different circumstances. And so we can play with the facts in Lange, for example, and turn that into something that looks more like an exigent circumstance or a hot pursuit of a felony, for example, and start to see, where do we draw the lines in these cases? And what does that mean in terms of officer responsibility, personal privacy, constitutional law, the court's role in all of this, right? All of those interesting questions, I think, come into the mix.
Yeah. Well, Steve, we've still got some interesting cases hanging out there. Drink your coffee, get some sleep. We'll see you in a couple of days. To our audience, thank you as always for joining us here, and we will be back.
Thanks, Kathy.